Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, May 8th, 2019. The time's 9:30. With us today are Commissioner Emily Lindley and Mary Smith, our General Counsel. I'm John Neerman, and I'll ask Ms. Smith to begin the proceedings.
Item number 1 is consideration of the ALJ's proposal for decision and proposed order concerning the enforcement action against Giving Good Luck Incorporated, doing business as Four Seasons Mart and CK Group Enterprises Incorporated. The order of presentation should begin with the ED, followed by the respondents, and then OPIC. By letter dated April 19th, 2019, each party was notified that they would have 5 minutes of oral argument in accordance with the Commission's standard practice. The ED may save time for rebuttal as the ED bears the burden of proof, and the Executive Director's staff is here to present the item.
Good morning.
Good morning. Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. My name is Logan Harrell, and I'm an attorney with the Litigation Division representing the Executive Director in this matter. With me today is Tyler Gerhart with the Enforcement Division, Corey Burke with the Corpus Christi Regional Office, and Thomas Clark with the Financial Administration Division. This enforcement case involves an underground storage tank system owned by CK Group Enterprise, Inc. and operated by Giving Good Luck, Inc. The ED alleged respondents committed 5 violations of the petroleum storage tank rules for a facility in Rockport, Texas. The ED concurs with the administrative law judge's proposal for a decision and recommends adoption of the proposed order with the inclusion of the ED's exceptions, which are intended only to clarify the order and correct minor typographical errors. We're here to answer any questions you may have.
Thank you. I have none. Commissioner Lindley,
I don't have any questions either. Thank you.
are the respondents signed in?
The respondents weren't signed in.
I think your mic is off.
The respondents weren't signed in.
Okay. See no respondents. Mr. McWhirter.
Good morning, Chairman, Commissioner, General Counsel, and the Executive Director's staff. I'm Sheldon Wayne for the Office of Public Interest Counsel. OPIC agrees with the Administrative Law Judge's proposal for decision and supports the incorporation of changes to it as proposed in the Executive Director's exceptions letter. As explained by Mr. Harrell, during the hearing and following presentation of evidence by the Executive Director, the respondents stipulated that they committed the violations and did not contest the proposed corrective actions, but did request reduction or forgiveness of the administrative penalty. All parties agreed to allow the respondents to participate in a financial inability to pay analysis conducted by the TCEQ, and the respondents agreed not to contest the results of that financial inability to pay analysis. OPIC notes that the financial inability to pay analysis could not be completed because respondents did not provide all requested documentation. The Executive Director filed a status report apprising respondents of the need for more information to complete the analysis, but neither respondent provided all of the requested financial information. As a result, respondents waived any claim of financial inability to pay the assessed administrative penalty and are joint and severally liable for the full penalty amount. OPIC agrees with the Administrative Law Judge and the Executive Director that the respondents committed the violations as alleged in the Executive Director's second amended report and petition. Further, OPIC agrees that the penalty recommended by the Executive Director is reasonable and was calculated in accordance with applicable statutes, agency rules, past agency practice, and the TCEQ penalty policy. Finally, OPIC finds that the corrective actions recommended by the Executive Director are both necessary and appropriate. For these reasons, OPIC respectfully recommends that the Commission adopt the Administrative Law Judge's proposal for decision, sustain all of the Executive Director's exceptions to the proposal for decision, and incorporate the changes as proposed by the Executive Director in his March 21st, 2019 exceptions letter. Thank you, and we're available for any questions.
Thank you. I have none. Commissioner Lindley?
I don't have any questions. Thank you.
Thanks.
Executive Director, any rebuttal?
No, Mr. Chairman.
I would imagine not. Commissioner, I think this is pretty straightforward. We have stipulations to the violations here. The one question I have is whether we might offer the respondents a payment plan, and I wanted to gather up your thoughts on that.
I would be fine with that if you wanted to authorize that or propose that.
Yeah, I think even though they were not able to demonstrate a financial inability to pay, appears to be some hardship here, and that seems like it would be appropriate to me.
I agree. And I can include that in motion.
Great.
If you're ready.
I'm ready.
I move that we adopt the ALJ's proposed order with the modifications recommended by the ED's exceptions and agreed to by the ALJ's reply, but authorize a 35-month payment plan for paying the administrative penalty and ordering provision number 1.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
Item number 2 is an application by Norhill Energy LLC for new Texas or TPDES permit number WQ00156666001. The parties have been notified that the commission will not take oral argument but may ask question. The individuals who have signed in on this item will be noted for the record.
Commissioner Lindley, we have several requesters on this item. I think most fail to demonstrate that they're affected persons, either because they're located far enough away from the facility that they're not affected differently from the general public, or they fail to identify issues that are relevant and material to this application. The exceptions to that, in my view, are Nicholas Thomas and the North Texas Municipal Water District. I think those two have established affected party status. OPIC had identified Mr. Montgomery and Ms. Reynolds as affected persons, and I think that's maybe a somewhat closer call than some of the others, but in my view, I think you need to infer a little bit too much in order to arrive at a relevant and material issue. So I would include Nicholas Thomas in the North Texas Water Municipal Water District, but exclude the rest.
I would agree. That's where I landed, and including those two in granting them party status in a hearing.
Great. So in terms of the issues, I think they can be boiled down to 5. That is the completeness and accuracy of the application, whether the facility will control nuisance odors, whether the draft permit is protective of water quality, whether the applicant has demonstrated a need for the project, and whether the authorization is consistent with the regionalization policy.
I would agree.
And I think it's appropriate to refer this to ADR to allow a hearing duration of 180 days and to deny the request for reconsideration.
I concur. I agree on all that.
Great. I'll entertain a motion.
Okay. I move that we grant the hearing requests of North Texas Municipal Water District and Nicholas Thomas, that we deny all remaining hearing requests and requests for reconsideration, that we refer the matter to the State Office of Administrative Hearings on the following issues. A, whether the draft permit is consistent with the state's regionalization policy. B, whether the application adequately demonstrates a need for each phase of the draft permit. C, whether the proposed discharge under the draft permit will be protective of water quality and the uses in the receiving waters under the applicable surface water quality standards in 30 TAC Chapter 307. Whether the proposed facility will sufficiently abate and control nuisance odors. And lastly, E, whether the application is accurate and includes all required information. That we set the hearing for a duration of 180 days from the day of the preliminary hearing to the date that the administrative law judge submits a proposal for decision. And lastly, that we refer the matter to the Commission's Alternative Dispute Resolution Program for a period to run concurrently with the preliminary hearing scheduling process.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
Item number 3 is a petition for the creation of North Lake Municipal Management District Number 2 of Denton County. The petitioner should present the matter, followed by any interested persons presently there and none signed in. The ED and then OPIC. The General Counsel's Office recommends limiting the parties to 5 minutes for presentations, and the petitioner may reserve time for rebuttal as they bear the burden of proof.
Mr. Green? Good morning.
Good morning, Chairman, Commissioner. For the record, my name is Tim Green. I'm an attorney with the Coates Rose Law Firm, and I am representing TMRY Ridge Limited Partnership, which is the owner, developer of all the property in the proposed district. Start over? Okay.
I'm sorry about that. You were projecting so well, I could hear you well, just fine up here, but I think in the back of the room, they weren't getting it recorded.
Again, for the record, my name is Tim Green. I'm an attorney with the Coates Rose Law Firm, and I am representing TMRY Ridge Limited Partnership. They are the owners, developers of all the property in the proposed district. We have obtained the consent of the city of North Lake to the creation of this district. We believe we have complied with all statutory and regulatory requirements requesting the creation of this district. And we would request that you adopt the proposed order granting the petition for creation of North Lake Municipal Management District Number 2 and appointing the initial directors. I also have with me here Mr. Daniel Dewey. He's the engineer on the project, and we'd be happy to answer any questions you may have about it.
Thank you. I have none. Commissioner Lindley?
I don't have any either. Thank you.
Great. Thank you, sir.
Thank you.
Appreciate it. Is there anybody signed in on this? Okay. Executive Director.
Good morning. My name is Kayla Murray, and I'm an attorney with the Environmental Law Division representing the Executive Director. And with me is Perinder Law with the District Section. The Executive Director received a petition from TMRY Ridge LP for the creation of North Lake Municipal Management District Number 2 of Denton County, pursuant to Chapter 375 of the Texas Local Government Code. We have reviewed the petition and concluded that all applicable requirements have been met. The ED recommends granting the petition for district creation, and we are available for any questions you may have. Thank you.
Thank you. I have none. Commissioner Lindley?
I don't have any questions either. Thank you.
Mr. McWhirter?
OPIC agrees with the ED's findings that the district would be feasible, practicable, and would be a benefit to the land within the district. We recommend granting the petition and approval of the order as presented by the Executive Director.
Thank you. And I agree with that. I think they've satisfied all their legal requirements and think it's appropriate that we go ahead with the order to create the district and appoint its initial directors.
I agree. With that, I move that we grant the petition for the creation of North Lake Municipal Management District Number 2 of Denton County and issue the Executive Director's recommended commission order for creating the district and appointing 5 initial directors.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you. Go ahead.
That takes us to the enforcement docket, which is items 4 through 32. Item 18 has been remanded, and the executive director's staff is here to present these matters. We have one person signed in for item number 7, but they have indicated that they don't wish to speak, so there will be noted for the record.
Good morning.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Brian Sinclair, also of the Enforcement Division, and Charmaine Backens and Janice Hernandez of the Litigation Division representing the Executive Director. Pending before you are items 4 through 17 and 19 through 32. The total assessed administrative penalties are $311,926, with $36,370 deferred, $20,604 applied towards supplemental environmental projects, and $254,952 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you. I have none. Commissioner Lindley?
I also have none.
Mr. McWhirter?
My office reviewed these items and we support approval of the proposed orders.
I think that's right as well, and I'll entertain a motion if you agree.
I do. I move that we adopt items 4 through 17 and 19 through 32 as recommended today by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you.
And that takes us to items 33 through 37, the quadrennial rule reviews for chapters 3, 10, 106, 205, and 326 of Title 30 Texas Administrative Code. And the executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. For the record, my name is Patricia Duran from the General Law Division, and with me today is Booker Harrison from the Environmental Law Division, representing the Executive Director. Pending before you are items 33 through 37, the adopted rule reviews of 30 TAC Chapters 310, 106, 205, and 326. As required by Texas Government Code Section 2001.039, the Executive Director's staff conducted rule reviews of these chapters to determine if the need for the rules within the chapters continue to exist. The proposed notice of the rule review of Chapter 3, published in the December 21st, 2018 issue of the Texas Register with a 30-day comment period. The proposed notices of the rule reviews of the Chapters 10, 106, 205 were published in the November 23rd, 2018 issue of the Texas Register with a 30-day comment period. The proposed notice of the rule review of Chapter 326, published in the November 9th, 2018 issue of the Texas Register with a 30-day comment period. No comments were received during the public comment period for these reviews. Based on the review of these chapters, the Executive Director has determined that the reasons for the rules continue to exist. We respectfully recommend approval of the adoption of the rule reviews of 30 TAC Chapters 3, 10, 106, 205, and 326. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. Project managers and attorneys assigned to each of these chapters, are here with us to answer any questions you may have.
Thank you. Commissioner Lindley, any questions?
No questions, thank you.
Mr. McWhorter?
OPIC recommends adoption of the reviews and readoption of these chapters as presented by the Executive Director.
Thank you. I agree. These rules still serve a purpose, and we should
agree.
adopt the reviews and readopt the rules.
I agree. I move that we adopt the rule revisions and re-adopt the rules in 30 Texas Administrative Code Chapters 3, 10, 106, 205, and 326 without amendment.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you.
And that brings us to item number 38, which is the public comment section. We don't have anyone currently signed in to speak.
Seeing none.
So that takes us to the end of the items for open session. And items 39 through 42 are for closed session, but the commission will not meet in closed session today.
The time is 9:48. We are adjourned.